So, Mr. Stevens, if you would do the legal report.
Expeditiously, yes. Can you hear me now? Yes. And I just wanted to touch upon a couple of the bills that were listed in Kurt's report, and Joe alluded to them. Kurt wanted me to mention them again, just the ones that potentially could affect the definitions of covered actions in statute. One in particular that we've been following is SB 1495 by Senator Wolk. It's being proposed by the Port of Stockton, but in effect it would give a statutory exemption for specified leases approved by the Port of Stockton, and also for routine dredging activities necessary for maintenance of the port facilities. And you may recall that in our own Delta plan, we have an administrative exemption. We call them administrative exemptions because we've determined as a category certain types of projects wouldn't have a significant impact on the co-equal goals, and so we're calling those administrative exemptions, not subject to the Delta plan, not covered actions. We have similar language in the Delta plan, but Senator Wolk's bill is subject to negotiation right now between the port and some of the big water users who have a concern that unless the definition is really tightened as to what routine dredging is, it could actually affect smelt habitat. And so there's some real technical language clarifications that are floating around right now, and we're monitoring that. But just I wanted to bring that to your attention, the issue of dredging, the issue of the deep water ship channel, smelt habitat. So with that, it's actually a privilege now to turn to the legal update, and I'd like to introduce your new legal intern, Ms. Tori Sondheim. I'd asked if she'd come to the table real quickly here, and this will be expeditious as well. Tori comes to us from McGeorge School of Law. I think I had previewed her appearance on the scene at the last meeting. She's really hit the ground running. We've given her the latest draft of the Delta Plan to review, and she's come up with some fantastic ideas going forward. She's also taken a look, as have previous interns, on the state of Delta litigation. There's always something going on. Turns out that the big cases that we typically follow, nothing much to report right now, but Tori does have a few cases that she's found on her own to give you a brief update about and tell you why it's potentially relevant to some of the issues that we're dealing with the Delta Plan. So with that, I will turn it over to Ms. Sondheim.
Thank you.
The first case
get that microphone very close to you.
Very close. How is this?
There you are.
Good. For the first case, it's In re Katrina Canal Breaches litigation. This opinion came out on March 2nd of this year, and it's relevant in particular if you look to the Delta Plan at the recommendation number 9 under the Flood, Chapter 7. This case basically has to do with the liability of the government in monitoring and creating flood. So it defines the protection of the government flood projects under the Flood Control Act of 1928. This act provides immunity to the United States for any damage via floods or floodwaters, doesn't cover flood protection when the government is negligent, and it also does not apply to construction for non-flood control purposes, which is the issue here. In this case, it was about dredging actual navigable channel, but on the side the government also implemented a flood control plan. And as part of that, people became injured, and the court decided that that it does not apply when it's not flood related. However, the
legal obligation to make payments for expenditures of benefit to property owners is not a federal obligation unless it relates to flood protection alone, not other purposes.
Exactly.
Got it. Okay.
And this also applies to personal injury as well as property injury. So the purpose of the Act was that there was a need for flood protection, that the government would be subject to excess litigation, especially since flooding was already a problem. And here this is similar to the Delta because there is a historical flood risk in the area. There's a need for flood management, and existing standards are being reconsidered pursuant to the recommendation. And basically, the Ninth Circuit is willing, again, to limit the liability, even knowing that other circuits like this circuit, which was the Fifth Circuit, because it was to do with Katrina, would not have applied that test. And we'll continue to monitor this case.
And can I just jump in? That was fantastic. Thank you for that. The policy that we'll talk about even later on when we talk about some of the open issues, as Tori alluded to, is a recommendation that we have currently in the flood chapter where we recommend that the legislature consider making changes to state law that would give state agencies the same level of flood immunity as the federal agencies currently have under federal law. So we'll talk a little more in depth later on. We're actually proposing to make a slight tweak or change to that, but this case is very relevant to that issue. So,
the second case I'd like to bring to your attention is the Carrick Tribe of California versus the U.S. Forest Service. This case came out on June 1st this month, and it took place in the Klamath, but it does apply to the Delta, and I'll explain that in a few moments. So first, basically the issue had to do with the U.S. Forest Service approving of notice of intents to perform motorized sluicing, suction dredging, other mining activities in the stream beds. And the tribe argued that that would affect the habitat of the coho salmon up there. And this court upheld the lower court's findings that, yes, there are issues involved and that they should consult with other federal agencies to determine what exactly the effect on the environment is. And the relevant portion of the Endangered Species Act here imposes all agencies a duty to consult with either the Fish and Wildlife Services or NOAA Fisheries Services before engaging in discretionary action. Now, this case earlier brought upon a different case, Leon Hillman versus California Department of Fish and Game. Now, I'm not going to get into that case, but the effect was that the Department of Fish and Game was required to suspend permitting until they perform a CEQA review. This is relevant to the Delta, even though it took place in the Klamath, because, first of all, there was a finding that suction dredging is bad for the critical habitat of, at the very least, coho salmon, if not other species. And in the Delta Reform Act, our strategy is to restore a healthy ecosystem, and obviously we're concerned about the critical habitat. And this also implicates legal recognition that other causes other than just flow and quality do affect these critical habitats, things like activities in the stream bed. There's recognition by the legislation through Senate Bill 640, which was signed in, which was the effect on the Department of Fish and Game, and in the judiciary, which also affected Department of Fish and Game. And finally, another implication is that the saga of suction dredging in California is not over, and competing CEQA claims could result in another round of CEQA review for the Department of Fish and Game, which could cause the Department of Fish and Game to be unable to complete their permits and allow miners to do this before 2016, and also the implication for takings, whether the government has to pay miners who can no longer get permits. And we'll continue to monitor the potential effects of this case as well.
Thank you very much. Appreciate that a great deal.